from supplementary for order notified item 6, first April 2 of 2022.
What has not been that is the defect for which I have filed I 2346 of 2020. For example,
346. A report has been received from the learned board. The learned council for the applicant has submitted that ID number 2346 of 23 has been filed for ignoring defect number 2 and 3. As pointed out in stamp report dated 2/2022 and 4/2023. It says that both the defects are relating to preparation of award. Both the defects.
yes. Preparation of award, and that is to be mentioned in para 1 and in paragraph prayer.
Yes, the learned council has submitted that. As per the report, the award has not been prepared.
Yes.
And therefore these defects may be removed. Considering the submissions, I number 2346 of 2023 is hereby allowed. The defect
Number 2 and
in connection with the defect number 1 as pointed out by
1.
the aforesaid defects are ignored.
No.
There is no surviving defects.
No, sir.
Defect number 2 and 3 being office is directed to place this case under appropriate heading, object committee, on next Friday. Next Friday, in the meantime, it will be open to the petitioner to remove the other surviving defects. Date for the petitioner.
17. Item 7, first appeal filing number 6902 of 2025.
Defect.
So defect is no हो गया, so defect को कभी address पर जोड़ना नहीं होता. After correction of
The learned counsel for the applicant undertake to remove the surviving defect. And the
correction for degree के लिए correction के गया था, आ गया. उसके हिसाब से सिर्फ एक हमको address के लिए जोड़ देते हैं. उसको case institution के लिए भेज देते हैं.
आप अभी कर लेंगे पहले
अभी कर.
office directed to place this case and application on next week. In next Friday.
Item 8, first appeal filing number 9940 of 2025. Item 9, first appeal filing number 12476.
लास्ट में डिफेक्ट रिमूव करने का बात मुझे आई हैव रिमूव ऑल द डिफेक्ट बट स्टिल मेंटेनेबिलिटी कर रहा है इस
That MA is to be filed.
यस हम एक फाइल की नॉमेनक्लेचर
Earlier has been filed for converting the nomenclature into MA instead of F.
one idea for the condonation of delay was 49 days.
तो वो तो बाद में ना पहले आप कन्वर्ट करना चाहते हैं आप कन्वर्ट करें
Yes,
आगे नंबर 9195 of 96 has been filed for converting the present appeal into a miscellaneous appeal. The learned counsel for the applicant has stated that the case arises out of probate case.
Yes.
Probate case out of pollutions with number 2 of 2016.
Probate saying right.
Okay. The case arises out of an application filed under Section 276 of Indian Succession Act, and a prayer was made for probate of the will dated 2/3/2007. Considering the submissions, the prayer is allowed, and the learned counsel for the applicant is permitted to carry out necessary corrections. In the memo of appeal, within a period of 2 weeks from today, upon such correction, the office directed to take fresh stamp application and proceed.
Appearance is-
Memo of appeal.
Item 9. First appeal file number 12472 of 2025.
Yes.
You know, should there is further stamp court fees of in 3 cases 9, 11, and 11, 5,000, 7,000, and 7,000. 4 weeks time limit.
The learned counsel for the applicant in all the 3 cases, अलग-अलग order of
9, 10, 11.
raised for and is granted time till 14th of August to remove the surviving defects breakthrough.
Okay.
If the defects are removed within time, post this case on the appropriate hearing on 18th of August.
Appearance is Item 12. First appeal file number 2060 of 2026.
Applicant absent. However, time till 14th August is granted to the applicant to remove the surviving defects breakthrough. If the defects are removed within time, post on 18th, let a soft copy of this order be forwarded to the council for the applicant to ensure compliance.
From bail list for orders with effect item 7. First appeal file number 3204 of 2025.
So is right, ma'am.
So, FA number 3 to filing number FA 3204 of 2025. The learned counsel for the applicant submits that there is a point of maintainability as raised by the office. He further submits that the pecuniary jurisdiction of the district court would be there to maintain the appeal. He seeks permission to withdraw this. With the liberty to oppose the appropriate. The permission, the appellant is permitted to withdraw his appeal with the liberty to take action against the impugn judgment and decree as may be permissible under law. The case was filed before this court on 21/2/2025 and has remained pending. The office is directed to hand over the certified copy of the judgment and decree as annexed to this memo of appeal to the limit transfer for the applicant upon being replaced by its photocopy. I've replaced
This-
OCL
Certified photograph.
certified.
In order to prepare an appeal before the approval.
That's that one, please. This goes on.
इसमें साइन करेगा
Dispose of as withdrawn with the.
Yes.
item 8 first
So
appeal
that
file
power
number
include order है sir.
Yeah.
2012
Yeah.
कब फाइल किया आपने?
उसमें भी कारण दिए हैं और ये भी दिए हैं कि एक्चुअली जो
ये
contestant
कोई बात नहीं, I was surprised.
I have to explain there. I have to explain that. They have already died. The lawyer who was dealing in the London trial court, he also died.
ठीक, कोई बात
item
नहीं.
8
इसीलिए डेट ऑफ फाइलिंग में लिख दिए.
Yes.
item 8 first appeal file number 5321 of 2025
Kind grant information.
Time till 14th August is granted to the applicant. So the defects are removed within time, post on 18th of August.
item 9 first appeal file number 7356 of 2025
Same one.
बस from date list permission item 31 first appeal 89 of 2026
All for the court of the consent court. The notice be issued to the respondents for the requisite under auditing process as well as the post. I think it's the post. We filed before this court within a period of 15 days. from today. 20. Since the letter copy of this order be forwarded to the Learning Council for the applicant to ensure compliance. Copy paste it in the plans. Post this case, office to tax people delivery, post this case on 28th August, awaiting submission.
item 32 first appeal 219 of
14th August, awaiting submission.
item 32 first appeal 219 of 2026
Entry, call for request from the concerned court. Let notice be issued to the respondents to the concerned police station for which requisites be filed before this court within a period of 2 weeks. Post this case on 21st of August, and it is understood. God for the records.
Item 33, first appeal triple 2 of 2026.
Yes. So, okay. Pass over. That's okay. That's why we'll admit it. Right? And that appearance. Sir, that appearance, admit. What for the cost from the consent form? Let me speak to the respondents. To the concerned police station. For which you can be filed within a period of 2 weeks. Post this case on 21st August 2027.
Item 34, first appeal 309 of 2026.
Yes. All for the cost was concerned. All for the costs for the concerned court. Let notice be issued to the respondent number 1 to 5. 1 to 6. Let notice be issued to respondent number 1 to 6. 1 to 5 to the concerned police station. For which request is filed within 2 weeks. So far as respondent number 6 is concerned, or the relevant counsel for document is directed to serve a copy of the memo of appeal along with its enclosure in the office of the alleged advocate. Post on 1st August, awaiting service.
From supplementary list for finance to item 1, WBC 2354 of 2019. Along with item 2 to 4.
Just a moment. Mr. Jayaprakash, what is your instruction?
Yeah.
You are ready for settlement? Okay, where is the respondent other side? So what would be the modality of settlement?
Modality is equivalent to the Jharkhand had date, issue number 4, 5, 6, 7, and 11. About the payments part, about damage part. So as per the transport cost, the amount है, we read it with me and थोड़ा समय तो चाहिए होगा because वो तो 5,000 10,000 करके मदर को दिया है, सिस्टर को दिया है. अब since we are the appellate, तो responsibility हम लोग को हो जाता है.
So you are ready to refund that
हाँ.
and retain the.
Yes.
Where is the earliest reason? And otherwise you are not ready to enter into a fresh development.
No.
They are ready to refund you the money.
With interest.
With interest, certainly.
My current is complete.
थोड़ा टाइम लगेगा लेकिन विद इंटरेस्ट तो होगा ही आफ्टर ऑल. आप लोग जॉइंट कॉम्प्रोमाइज
But client. उसमें भी लॉट से एक टाइम फिक्स कर दिया जाएगा इतना टाइम
के अंदर जॉइंट कॉम्प्रोमाइज फाइल करिए ना उसी में टाइम आ जाएगा.
उसमें
बोलिए तो मीडिएशन में भेज देते हैं.
नहीं यही से हो जाएगा.
यही से हो जाएगा सभी लोग कर देंगे ना.
हाँ यही से हो जाएगा.
आस्क हिम प्लीज.
According to us, Lords, the interest is 18% in my client, Lords. According to my client, Lords.
Simple interest.
18% interest.
Simple interest. This is what you have claimed. You have not claimed any compound interest.
May kindly see my claim plots to
Yes, yes, I've seen that.
His claim
18% simple interest.
इनका जो भी क्लेम था वो कोर्ट डील किया है इश्यूज नंबर 4, 5, 6,
ठीक है,
7
कोई बात
एंड 11 में।
अब बताइए मोडालिटी के लिए क्या जॉइंट कॉम्प्रोमाइज फाइल करेंगे बैठ के?
सर बना देंगे हम लोग, देख लेते हैं उसमें कुछ चेंजिंग
ठीक
करना हो,
है,
सर ही
आप
बना लेंगे,
इंस्ट्रक्शन ले लीजिए।
सर ही बना
ये
लेंगे।
लुबिन का क्लेम था दैट वेंट टू अ ट्रायल, तो ट्रायल को पेमेंट्स पेंडिंग जो पेमेंट्स का है 4, 5, 6 एंड 7 में दिया है, माना है ये इतना सा पैसा दिया है, दैट ट्रायल कोर्ट हैव एक्सेप्टेड, वो हम लोग दे देंगे जो भी
विद
ट्रायल
इंटरेस्ट
कोर्ट जो भी इंटरेस्ट दिया होगा।
इंटरेस्ट रिफंड का किया ही नहीं है ना?
नहीं किया नहीं,
ट्रायल कोर्ट ने कहा रिफंड का ऑर्डर किया।
अच्छा उसको नहीं किया।
ट्रायल कोर्ट ने तो मतलब स्पेसिफिक परफॉर्मेंस का ऑर्डर
हाँ
किया, इसीलिए सर
उस पर तो
रियल स्टेट का बात है।
अच्छा इशू नंबर 11 जो है उसमें क्लेम के डैमेज का कोर्ट ट्रायल कोर्ट बोला कि कोई प्रूफ नहीं दे पाया
जितना पैसा दिए हैं
हाँ
उतना पैसा आपको 18% इंटरेस्ट के साथ मंजूर है?
इंटरेस्ट ज्यादा नहीं
नहीं सर, इंटरेस्ट बिल्कुल ज्यादा नहीं। रियल स्टेट के मोडालिटीज को देखकर आप एक चीज देखिए, डैमेजेस आप नहीं दे रहे, ठीक है? जितना पैसा लिए हैं उतना आपको पेमेंट करना है। अगर आपको मंजूर है तो ठीक है, नहीं तो हम लोग तो सुन ही रहे हैं मेरे, ठीक है? बोले कि आपके क्लाइंट आ गए।
इंटरेस्ट पार्ट पे पर
सर वो हम तो नहीं नेगोशिएट करने की स्थिति में है, हम तो डिसाइड करने की स्थिति में। I'm not here to
ठीक है आप मत किसी भी हम ये कह रहे हैं कि इसको एक दिन
सर
और
मीडिएशन में भेज
नहीं यही रख दीजिए, यहीं से हमको मिल जाएगा। मैं
एक दिन और दे दीजिए आप, कल उस पर हम लोग कैलकुलेट कर लेते हैं क्या होता है।
हम कैलकुलेट कर लिए।
आपके for the benefit of your client, 50 lakhs का damages they are foregoing, and जितना पैसा लिया है उसी पर इंटरेस्ट मांग रहे हैं और आप अपना कैलकुलेट कर लीजिए।
हम तो कल तक कैलकुलेट किए हैं,
कितना होगा?
7 करोड़ से ऊपर जाएगा।
7 करोड़ से ऊपर। अच्छा 18% इंटरेस्ट।
18%
आप जरूर उस पर कंपाउंडिंग कैलकुलेट कर दिया होगा।
वो तो नीचे सीए से करा के लाए, सीए से करा के लाए।
सुनिए यहाँ पे नहीं होगा मीडिएशन, there is an element of settlement between the parties।
वहाँ हम लोग नहीं रहेंगे ना, सर रहेंगे ना, हम नहीं रहेंगे, नहीं हो यहीं पर कर दिए जाएंगे, बढ़िया हो जाएगा। हमको लग रहा है यहीं से हो जाएगा।
The learned counsel for the parties have submitted that the matter could be settled out of court and accordingly they seem adjourned। बताइए आप लोग बैठ के अपने टेबल में
ये हम जो कैलकुलेट किए, हम जो सीए से कर तक जूम कर
ये कंपाउंडिंग है।
कंपाउंडिंग
इंटरेस्ट का तो आपका प्लेयर ही नहीं था। कंपाउंडिंग इंटरेस्ट का कहाँ से सपना देख रहे हैं?
अच्छा 18% जो मेरा है,
I tell you कितना होगा टेंटेटिव होगा 1.5 से 2, इससे इतना ही, इसके बियॉन्ड नहीं।
18% इंटरेस्ट को कम नहीं किया जाए।
हम तो कुछ भी नहीं बोल रहे हैं।
सर
मान लीजिए नहीं मान
guiding
लीजिए I will not say anything कि आपको सेटलमेंट कितना में करना है। We have no jurisdiction to say anything on that. We have only jurisdiction to decide.
सर कुछ टाइम लग रहा है।
नहीं आप लोग बैठ जाइए, बात कर लीजिए क्या पॉसिबिलिटी है, क्योंकि ये डेवलपमेंट एग्रीमेंट तो नहीं लग रहा है कि इट इज गोइंग टू, और आपका जमीन भी फंसा हुआ है, इसका पैसा भी फंसा हुआ है एंड नोबडी इज पेइंग। तो सोचो कि फ्रेश डेवलपमेंट एग्रीमेंट हो सकता है, ऐसा लग
ऐसा करें तो हम तो तैयार हैं करने के लिए, इन्हीं के टर्म एंड कंडीशन पर हम तैयार हैं। 50% देंगे।
9 से तो देख लीजिए 26 से कुछ बने
नहीं नहीं, आपको 12 के बाद तो
आपने
Loss-
अपने
loss of
क्लाइंट
trust।
के बारे में बात किया है, फ्रेश डेवलपमेंट एग्रीमेंट के बारे में कोई बात
इनके साथ लॉस ऑफ ट्रस्ट वाला बात
थोड़ा सा
करना तो है आपको फ्रैंकली बता, बट इनके साथ में लॉस ऑफ ट्रस्ट
कोई बात
लॉस ऑफ ट्रस्ट की बात
बताइए कब
नहीं। एक लाइन और खाली बोलना है, इन्हीं के भाई बोल रहे हैं गवाही में कि या मेरे चाचा शहनवाज
आप गवाही पे आप कौन
50 लाख रुपया हमसे नाजायज मांग रहे थे, बोले 50 लाख दीजिए तब हम शुरू
कोई
करेंगे।
बात नहीं, आप बताइए ना कब रख दिए इसको?
हम तो तैयार हैं कि पूरा पैसा और 18%
नेक्स्ट
इंटरेस्ट
फ्राइडे को रख दिए।
बिल्कुल रख दिया जाए। तैयार नहीं है।
कम से कम एक बार ये तो बता देंगे कितना में सेटल हुआ या हुआ भी कि नहीं हुआ। सूद तो लिए हम काफी
अदरवाइज लॉ देखिएगा तो इंटरेस्ट एक्ट अगर देखिएगा तो इंटरेस्ट कांट बी
देखिए सर
मोर देन
इंटरेस्ट एक्ट से ये नहीं चलेगा कमर्शियल ट्रांजैक्शन एफडी नहीं किए हैं 6% इंटरेस्ट मिलेगा आजकल एफडी का रेट और कम हो गया 5%।
बहुत कम
6.6 हो गया।
It's not FD.
तो मिलता होगा सीनियर
नहीं हम सीनियर सिटीजन हमको सब सीनियर सिटीजन बना देंगे।
पता नहीं नेक्स्ट फ्राइडे रखने हैं? Okay, post this case on next Friday in the supplementary cause list to be taken up at 2:15 as the first case. The parties to inform Ms. Court as to whether they have in principle agreed for settlement. आपको उनको भी लूप पे रखना पड़ेगा कि जो भाई है
हाँ
भाई लोग
हाँ इनके भाई तो हमारे फेवर में सब एविडेंस दिए हैं।
जो भी है
उनका भी साइन
ज्वाइन करना पड़ेगा ना
उनको भी साइन करना पड़ेगा। देखिए
Item 1,
टाइम इज द ओनली मनी टेल योर क्लाइंट्स लिटिगेशन तो चलते रहेगा टाइम इज द ओनली मनी
agreement was that time in the essence. This is Article 12 of the agreement itself.
Item 1 WBC 2354/2019 along with item 2 to 4.
इस मिस्टर आशुतोष आनंद आओ ही क्या हुआ था कल
कल बहुत चीज हो गया था एक साथ।
आर यू ओके नाउ
हाँ यानी कि I took rest in the first half. I'm okay. I took rest in the first half.
क्या हुआ था अचानक
फीवर खांसी चलते हो गया था बीपी लो हो गया था और I was shivering थोड़ा नहीं so I got everything tested everything is okay except for this cough.
My senior investigate some steps giving seeking some accommodation in the matter as settlement.
By the time जब तक सीनियर के छत्र छाया में थोड़ा बताइए क्या है
The matter is pertaining to the ESIC exemptions which have been claimed and
it has been rejected
it has been rejected in all the 4 cases.
orders have been passed
Orders have been passed and authority has been rejected. In the first case,
similar the nature of orders are same
2 cases related which has been which is the 2354 and 2794. Certain grounds are there which are different from the other cases.
the fresh order has been passed pursuant to the order of the High Court.
Fresh order has been passed.
So what is your ground
In
you are taking the medical benefits from Tata main hospital or the Telco
there is tie-up with all the other hospitals of Tata. In this
just first you have tie up with Tata main hospital or Telco hospital
Tata main.
Tata main hospital
Tata main.
Tata main hospital has tie up with many others.
Tata main and the company
Are
is
you also entitled to the same tie-ups?
same.
From where do I?
We have stated this in one of the petition itself and before the SIC as well, wherein they have stated in other 2 petitions that they have taken a ground that you have a referral facility, we have a tie-up
So
facility.
that is a separate. Where is your agreement with TMH?
Agreement is on record. However, it has been accepted by them also. By rejecting also, they have stated that you have a referral facility, we have a tie-up facility, which we have demonstrated by their own rule of leadership that their referral facility is merely a wordplay used by them, as they even need a referral to be done.
In first case, there are 4 grounds of rejection.
There are 4 grounds of rejection.
First is that you don't have
dental facility.
Do you have or you don't?
Leadership, we have tie-up with the hospital and every facility available in the hospital is available. Just because nobody availed the dental facility, they cannot per se assume that we don't have a dental facility.
Fair enough. So for dental facility, they must have File they reply before the authority. Where is the order of the High Court?
Order of the High Court in page number 79. The matter was presented by
79.
it starts from 79. The discussion is at page number 80.
And where is the previous improvement?
Which is 78, just a previous.
Which all are the common grounds?
Similar grounds have been
Same.
taken.
Right?
It is
So
Yeah.
after the order passed by this court, you must have approached them.
Yeah.
Where is your representation? At least satisfying these grounds. That yes, these grounds are not good grounds for rejection. Because now you know that what is going on in their mind. So your representation should have disclosed and should have met with all these grounds, isn't it?
Yes.
Tell me where is it? What did you do after the order passed by this?
It should be approached that we
Where is
presented
that
all
letter? Where is that letter?
letter has not been annexed.
So how did you approach? How did you satisfy them?
The matter was limited that before the hearing
See.
was
Just a moment. In the earlier improved order, there were 4 grounds. So at least you should have intimated the authority that these are the 4 grounds which are not correct. Where is that?
we have annexed the MOU of 2020, which is
MOU of 2020.
22, but in this case only itself, at annexure 9.
No, we are not concerned. We are concerned with the materials produced before the authority. You produce whatever you are saying. What happened after the order of this court?
After the order of the court, there was a hearing.
Mr. Das, the fresh improved order is copy paste.
Copy paste of this service.
So I just want to know that when you were granted an opportunity of hearing, what did you do?
We produced in those documents are there in the rejoinder also.
Which documents?
So the comparative chart, the other rules of our company, everything we have produced. And also they have just without any application of mind, only the authority has changed.
You were heard or not? Very heard.
Yes, we were called in one date. What happened previous occasion, Your Lordship? The joint secretary passed the order.
That's why I
Therefore,
am
it was,
aware of it.
yes, Your Lordship only. Now, Your Lordship, the secretary, what he did after hearing everything was a fatal exercise, he just copy pasted the same order.
So therefore, I want to know these are the 4 grounds. What did you find any representation saying that these grounds are not proper, these are not correct because of this document, this ground is not proper? What have you done?
Lordship, when we appeared, Lordship, the respondents also appeared, they also filed, Your Lordship, one reply. Wherein these were not the grounds on which they objected. Lordship, their objections are also on record.
You see, the authority has to
Apply their mind.
They have given 4 reasons.
Yes.
Are these reasons beyond the provision of the Act?
Lordship, the reasons which they have given,
Yes.
Lordship, I would say, Lordship, that
Let us see one of them.
yes,
First
first, टाटा कम्युनिस्ट जमशेदपुर अपने कर्मचारी को 2005 से 2008 तक जन चिकित्सा सुविधा नहीं प्रदान करता था. There is no basis of saying so. किंतु ESIC के अंतर्गत कर्मचारियों को दंत चिकित्सा सहित सभी प्रकार की बीमारियां का चिकित्सा उपलब्ध है.
तो आप हमको बताइए ना, मतलब you have to, it is due for you to demonstrate that this facility was available.
So there are 4 cases of the petitioner. two cases they have copy pasted the same order. And
So
two cases.
we take case by case.
Lordship, our specific cases during that, Lordship, we have a regular dentist here, Lordship, in Tata Motors Hospital as well as in our dispensary. Lordship,
This is Tata Motors or Tata Main?
Lordship, this is Tata Motor Hospital. Yeah. Plus, we have, Lordship, I'll show it from the record, we have tie-up with three hospitals, Tata Motors Hospital, Tata Main Hospital, and another is Tin Plate Workers Hospital. Three hospitals, direct tie-up, any of the workmen can go to either of the hospitals, and thereafter referral hospitals.
So you have separate referral hospitals also.
Separate referral hospitals list given.
Where is that?
Our design.
You see,
Just give the list.
let us see one by one. You have given the reasons, whatever you have to say. Para 20 Roman 1. Para 20 Roman 1.
Page 423.
Page 23.
Yes. 2000 for the period 2005 to 10, there was no single instance on behalf of the employee seeking assistance for dental treatment or reimbursement of expenses incurred for dental treatment, and as such, barely mentioning that during the period no dental treatment was provided to the respondent authorities erroneously in rejecting the said application on that.
Let us see what reason they have assigned.
They said that we never used to provide dental facilities. during-
सुविधा नहीं. So you have to only say that you have the facility.
Yes.
What कोई लिया कि नहीं लिया is immaterial. But you do not say that you have the facility. And the reason is not that. The reason is that you do not have the facility.
Yes. Also, for that also, to demonstrate that fact also, we have not on record the I'll just show you. With our agreement with Tata Main Hospital, the dental facilities are included.
Where is it?
Just
Now park this and come to the second. That you do not provide facility beyond 75 years.
yes. That also we have given that.
Give the explanation. Read your explanation.
Yes. We don't want to anything. The average life expectancy of the country as per data is 67 years. As such, the petition company had decided to provide facility to its employees up to the age of 75 years. And in the recent past, further in the period during which such exemption has been sought, there was not even a single instance where an employee aged more than 75 years has sought medical assistance. This apart, the petition company also provides free medical treatment to the spouse of the employee up to the age of
That is
75 years.
immaterial. This cannot be a reason.
But for them also, if your lordship sees there, for they apply, they take additional yes,
Whatever be it.
contribution for that.
Whatever be it. But 75 साल के बाद ही मेडिकल रिक्वायरमेंट शुरू होगी आज के समय.
तो उस समय 2005 से 2010 का है.
2005 से 2010 में 67 years में लोग मर जाते हैं.
नेशनल रिकॉर्ड जो है.
You see, whatever it is, but you do not, admittedly, you do not provide facility beyond 75 years.
And admittedly, lordship, they also provide it on receipt of certain money in
Maybe.
addition to after
Maybe you
retirement.
also take certain money and provide to be matching.
Yes.
No, नहीं चलेगा Mr. Glass.
लordship, same grounds पे
75 साल के बाद का कोई आदमी आएगा तो उसको क्या बाहर निकाल देंगे?
नहीं, हम लोग तो निकालते नहीं है, लेकिन जो हम लोग का सर, आज तक बोले कि आज तक कोई ऐसे आया नहीं है.
आपको क्या ही पता गेट से बाहर निकाल देंगे तो आया नहीं उसको रजिस्टर ही नहीं करेंगे. Who knows? Because your important is that 75 साल के beyond नहीं.
So when your lordship is matching, lordship will say certain benefits are better.
I'm
than-
not matching, nor I'm in appeal. I'm in read to.
Read this, lordship.
I will only see whether it is matching.
Yes, then lordship you have to see, lordship, there are various facilities which are better than them in as much as. Lordship, I'll just give the example.
You see, the person who is more than 75 years of age, according to your policy, you don't grant them the benefit of admitted.
Yes, that's
So
why.
ground number 2
Hmm.
is very much there.
Lots of.
You cannot
No, we have
ignore
stated and
ground
we have
number.
also mentioned the data that after 75 there is not even a single instance.
इंस्टेंस होने का जरूरत नहीं, फैसिलिटी होने का जरूरत। इंस्टेंस तो कोई आएगा तभी ना जब उसको पता होगा कि भैया तो मिल सकता है। जैसे ही 75 हो गया वो चला गया दूसरा जगह, he will not come. And
Lakshmi, kindly come to page
third,
just for that. Lakshmi, kindly come to page 54 of the report.
54.
Yes. हम लोग का तो 75 तक फ्री ऑफ कॉस्ट है। लक्ष्मी kindly come to page 54.
Yes.
Lakshmi, 14. In section 56 of the Principal Act and subsection 3 of the third proviso, following proviso will be substituted. Previously it was not there. So after superannuation no benefit, provided that.
This has come into effect from 24th of May 2010.
Yes, before that there was no provision for retired army. This is for 2005 to 2010. Actually, they introduced also for retired employees. Actually, we have to compare it with them. Provided that also the insured person who has attained the age of superannuation. This is a new provision which has been introduced. Prior to that, after superannuation, yes. Provided that also an insured person who has attained the age of superannuation, a person who retires under a voluntary retirement scheme or takes premature retirement, or his spouse shall be eligible to receive medical benefits subject to payment of contribution. Such other conditions may also be prescribed by the central government. So prior to 2010, even this benefit was not there with them.
So retired employees were not entitled to any benefit prior to 2010.
Yes.
This is what you want.
Yes. And after 2010, section 56 also this proviso was added. And for retired employees, they have to pay contribution. And in our case, till 75, no contribution, free
That's
of
right,
cost.
but maybe free of cost.
Yes.
But only till 70.
Only till 75, they did not have till 70, 60
Yes.
also.
We'll
Yes.
see that.
Yes. So this is my submission.
Yes, this is one. What is third one? ESI के अंतर्गत बेरोजगारी भत्ते का प्रावधान है।
Yeah.
जबकि टाटा कमिंस लिमिटेड जमशेदपुर में यह प्रावधान नहीं है।
बेरोजगारी का हम लोग लिखे कि कंपनी जब चल रहा है लास्ट समय से बंद होने का कोई नहीं, बेरोजगारी का कैसे करके
There is no question of any बेरोजगारी। बेरोजगारी भत्ता भी आपका इंश्योरेंस में है।
अनएम्प्लॉयमेंट अलाउंस है, हम लोग बहुत सारे
अनएम्प्लॉयमेंट अलाउंस इसमें
वही बेरोजगारी भत्ता, उसका रीजन है कि वी हैव सीन दैट वेरियस कंपनीज अंडर द टाटा इन अदर केस दे हैव वेंट इनटू बीएफआर प्रोसीडिंग्स। तो टाटा स्काई में जो मर्ज हुआ है अभी आईएसडब्ल्यूपी, तो अगर हैड दे बीन इंश्योर्ड वी वुड हैव बीन पेइंग देम अनएम्प्लॉयमेंट अलाउंस फॉर द एंटायर क्लोजर पीरियड। वी नेवर नो व्हेन कैन अ कंपनी गो इनटू सिक, व्हेन कैन बी डिक्लेयर्ड सिक, वी नेवर नो दैट। दिस इज द सोशल सिक्योरिटी।
So whenever any company is under crisis and
It is closed down.
it is closed down. So there is a provision for
Definitely.
unemployment.
This is from 2005 itself.
This is from 2005.
There was a special scheme which ESIT launched with the name of Rajiv Gandhi.
So इनका कहना ये है कि टाटा कमिंस एंड टाटा कंपनी इन बंद नहीं।
We have seen various cases under the Tata group itself. They have closed down.
कोई कंपनी बंद नहीं हो सकती।
Yes.
Under the IBC proceedings, no company can die. Company can be taken over.
ऐसा नहीं है।
उस पीरियड में तो बंद
जो
रहा।
कंपनी टेकन ओवर में नहीं आता है। IBC is what? Sending a patient to ICU, right? When multiple specialities are there to treat the company. But if the company is not worth reviving, it goes to liquidation. ऐसा थोड़ी है कि liquidation नहीं होता, it goes to liquidation. And then whatever be the modality of distribution.
And during liquidation also many times the companies are closed.
Anyways, this is certainly not a medical issue.
No, this is because we do not foresee the situation that we will get closed.
That's you do not foresee, therefore it is not. What is your explanation with respect to this?
The Roman 3 also page 25.
Yes, we
The petition company is operating since last several years on the question of employees becoming unemployed in absence of any order of termination for their misconduct does not arise as such. Rejection of the application on that ground that there being no provision of employment allowance, it should be unemployment allowance is only misconception.
Now The fourth one is that there cannot be any
Give
retrospective.
retrospective. They
So
delay.
that has come up only in the year 2010.
Yes.
Prior to that, there was no such
No,
clause.
and secondly, Lordship, it was delay was on their part. They kept it pending, then they
And
passed
by
an
virtue
order.
of the order of the court,
Court,
they were
yes.
supposed to pass the order.
Yes.
So this, you can say, is misconceived.
Yes.
ये पहला वाला दंत
हाँ,
चिकित्सा
Yes.
तब तक आप बताइए this 75 this amendment which has come up. So prior to that you had no such
But first of all,
facility.
there is no pleading to that effect.
Okay,
in public
anyways,
domain. And
we
this
are
appears
showing
to be
something
this
which
appears
is-
to be a substitution. I am just checking, so I don't have the
Yes, I
previous
have
act. पुराना act मेरे पास नहीं है, नया act है. So what was the earlier unsubstituted thing? This is required to be seen.
Concept इसमें amendment of section 65.
Section 56. से पहले. It was there. It was there. There was certain additional terms which were changed. VRS enforcement, premature retirement, basic term, at the bottom, my lords.
Yes. It was there, Mr. Kass. You can have it. Is it?
नहीं, मेरे पास भी नया ही है.
Yes, it is there on payment of contribution.
So.
But it is a paid service.
Yes, yes. You have not provided any service.
No, we have provided till 75 free of cost.
Free of cost. उसके बाद
उसके बाद silent है.
it is not packing. You cannot say it is not.
But your lordship, same benefits they have given us for some years, and other years while rejecting they have selected other grounds.
Which all years they are giving you.
Yes. And lordship, regarding the dental also, we have annexed the memorandum of scheme settlement of the year 2022, wherein we have stated that we'll continue providing you Lordship.
2022. We are not concerned with 2022. You have to show us for the period involved in this case.
But there the recital is we'll continue providing the
We are not
dental
talking about
facilities. Yes. That is at page 53, but I'm just pointing out to you, so that is at page 53 of our agenda.
The grounds you are trying to meet through a rejoinder.
But the grounds which they have rejected was not the ground on which it was objected by the PSIs. Therefore, we have brought
It is
into
there
their
in the
objection.
accused order.
Yes.
The authority is adjudicating.
No, we have stated that there is a facility only because there was no reimbursement claim during that period.
Which document are you referring to?
Lordship, this is the memorandum of settlement, page 53 of the rejoinder, if your Lordship comes. Lordship, will kindly come to the third paragraph. As agreed, the medical claim facility of to retired employees and their spouse will continue. Dental treatment facilities at TMH and Tinplate Hospital also will continue.
Page 53.
Yeah. Third paragraph. Until Lordship.
This is of the year 23rd August
Yes.
2023.
Yes. At the very outset, etc. But
This is a
that
memorandum of settlement.
wage settlement, it is wage settlement.
Yes.
There we have mentioned that it will continue to provide you. Now, you should take into consideration the exemptions which has been granted to us. That is Annexure 8, page 83.
It's page 83.
Annexure 8.
This is for the period.
Annexure 8, page 83 is for the period 1/4/2016 to 31/3/2017. This they have granted on the financial year basis.
Then there are
I beg your pardon, sir.
These are for Tata
It is
Motors.
Tata Motors. Ours is that in the rejoinder we have filed it. Ours is that Annexure 10 series in the rejoinder page 83.
annexure
10 series, page 81.
10 series. Which period is this?
So this is 1/1/2015 to 31/12/2015. Thereafter, Lordship,
15 and 16.
16 years. 1/1/2016 to 31/12/2016. And Lordship, in fact, from 22 onwards, we have stopped taking your Lordship any exemption because Lordship, all the employees we have
Cross-check.
So the you have whatever you have annexed on the basis of which it has no relevance because that memorandum is of the year 2023.
Yes, 22. We have last application we have made up for the year 2022. Then 23 onwards, Lordship, the salary of all the employees have. Now again, if they revise their rates, again we may fall.
That's all.
So in this case, Lordship, our grounds are Lordship. First, Your Lordship, we have stated that there is no basis to say that there was no dental facility at all.
No, you don't need to repeat. We have seen whatever we have stated.
Just have Lordship crystallizing it.
Every point has been dealt with in your
Yes.
big petition.
Yes.
Point by zero.
Point was printed, and the order is of without any application of mine. He has simply recasted the same order. The authority has only signed.
First, other thing is, twice they were given an opportunity to substantiate these four aspects. In fact, these three. First, at the time of the first hearing, though it was passed by an authority who did not hear the matter. After remand also, they again could not satisfy the authority with regard to any of these three grounds. So these three grounds are material grounds, which itself is enough to hold that the benefits are not substantially similar. And these are material grounds.
Where is your application for exemption?
Original.
Connection only. We start from page 41. So every year
Total number of employees you have mentioned is
415.
450.
Right.
Yes.
any demand raised upon them so far?
I'm not sure whether this aspect has not been.
But the employees that they have shown,
Is 415
Below
below the
rupees
wage
10,000.
below the wage limit.
no, below rupees 10,000
At that time,
10,000
it was 10,000.
It was 10,000 done.
at that point of time. So far as this is concerned, there is no dispute. Because in the
This is
exemption
their
application
application,
also,
this is their
there is nothing.
And if you also see serial 11, total employees at that time was 855. Below 10,000 it was 450.
Or the learning council secretary on behalf of the clients.
Legal issues also, the compilation is the same in also with the, but I got an additional compilation for the putting these cases also. Same judge. Initially we made it for all the cases I was implementing, but
No, I don't know that there is any judgment which is directly applicable to the practice cases.
the judgments which on the issues I'll just tell you. I've already seen the judgments. One is if for certain years they have given, certain years they are denying, then they should at least satisfy the court that
Which
it
is that judgment that you
Lordship, that is 2022 SCC online Calcutta 3996 para 16 and 25.
Calcutta 3996 para
Should I pass over?
16 and just a moment, 16 and 20.
25.
For similar situation for different years.
Different years. Second is Lordship. Another judgment is 2024 SCC online Calcutta 431.
SSC online
Calcutta
Calcutta
431.
para
Para 17, 20, 21 and 22.
17, 20, 21, 22. On what point?
Which are the same issue.
So one judgment is more than sufficient.
Yes.
One judgment is more than sufficient.
Yes.
Then why do we need to multiply this? Which one should I retain out of them?
What should we take this? What should the issue be? What should we take two judgments on this issue? I will not take this. The first one is 2022 SCC online.
2022 SSC
SSC
online has
online
been followed
And there are
in
one is
2024.
no 2024 Gujarat law should be taken into consideration.
Okay, this is one is Calcutta.
One is Calcutta, one
Which
is
one should
Gujarat.
I retain? 24 or 22?
22 years.
20. Okay, fine. Then
And
second
second
one is
Gujarat year also 2000 SCC online Gujarat 605.
2000 SSC
2024
Gujarat.
Gujarat
Para page
605.
number?
Para 605.
Page 605.
Para
number?
10. And then your lordships. One is Jardine Henderson lordship said that lordship, there was a direction of the High Court to continue to provide the facilities. Here also, though there was no such direction, but it is a fact that we had been providing the facilities for all these years, and lordship, we have given the breakup of the expenses also which we had incurred. So lordship, at this stage, lordship, after we have provided the facilities, lordship, if the contributions are directed to be made, your lordships, because they admittedly ESIC did not provide any facility. It is the
This
insurance.
judgment is
Yes, 2006 volume 6 SCC page 581.
5.
The distinguishing factor which your lordship also pointed out was that in those, but lordship here that will not make any difference. In here, it is nobody's case that we did not incur that expenses. And last is lordship, one judgment passed by this honorable court, WPL number 4766 of 2022, Gemco. While argument, lordship, my learned friend also lordship relied on the situation of Gemco that they went in a closure and therefore this is necessary. In their case also the
Which
exemption.
is that judgment date?
Actually, it is a judgment date 2000. The judgment is, I just give the date.
Convict bench of this one.
Yes, lordship had already seen that judgment. It is dated 24/7/25.
ये वही मैटर है टाटा स्टील वाला।
Tata Steel.
और ये वाला जजमेंट है हमारे पास।
मैं सारा कंपनी से
That's all?
now lordship, should I see the other cases also?
आपको दो बैच करना है।
नहीं 4 cases है इसीलिए.
नहीं, एक-एक करके decide। 4 केस।
Lordship, why 4 cases are necessary to be had together in this? Lordship, same situation, same company. Lordship, 2 cases they take similar grounds, 2 cases they take some other grounds.
दो केसेस जिसका सिमिलर ग्राउंड है। एक
Just-
दिस इज फॉर व्हिच पीरियड 4 इयर्स।
This is 4 years, 2005, no, 5 years, 2005 to 2010.
Oh.
And the other is 2794 of 2014.
नहीं, ऐसा है कि हमको आपका सबमिशन लिख दीजिए, नहीं तो मिसमैच हो
जी,
जाएगा। All the learned counsels appearing on behalf of the parties, district petition has been filed for the following relief. The learned counsel for the petition submits that the period involved in this case is from 2000,
5 to 2000.
2005 to 2010. He has submitted that earlier the petitioner had moved this court in the PC number 1470 of 2012. And the said petition was filed primarily on the ground that the person who had heard the petitioner was not the person who passed the order in that case. The learned counsel submits that the matter was remanded to the competent authority for granting an opportunity of hearing and passing of judgment. Paragraph 8 of the aforesaid order dated 23/10/2018 passed in the DC number 1470 of 2012 is to be observed. The learned counsel submits that after the order dated 23/10/2018, the parties appeared and hearing was granted, but the fresh improved order is practically copy paste of the earlier order which was impugned before the previous writ proceedings. The previous order is contained in Annexure 5 and the fresh order is contained in Annexure 7. The council says that the order contained in Annexure 7 is a piece of complete non-application of 19, and the order has been passed mechanically without considering the materials on it. The learned counsel, by placing the interim order, has submitted that there are 4 reasons for denial of exemption, and each of the reasons has been dealt with in the writ petition in paragraph 19. In paragraph 20, the 4 reasons for rejection has been mentioned in paragraph 19. Paragraph 19 and 20 of the writ petition is quoted. With respect to the first reason, the learned counsel has referred to the memorandum of understanding between the employer and the employee dated 23rd of August 2023, and has in particular referred to internal page 39 and running page 53 of the rejoinder. To submit that, it has been mentioned therein, inverted comma, as agreed earlier, the Mediclaim facility to retired employees and their spouse will continue. Full stop. Dental treatment facility at TMH and Teamplate Hospital will also continue. Inverted commas. The learned counsel submits that the fact that the earlier facility was sought to be continued through the memorandum of agreement dated 23rd August 2023 reveals that the dental facility was available to the employees even in the year. It can be seen that the dental facility was available prior to that date, and therefore the first reason mentioned for rejection of exemption is not tenable in the ISA. With respect to the second reason for rejection, the learned counsel submits that the period involved in this case is from 2005 to 2010, and the facility for treatment of retired employees was introduced in the year 2010 by way of Gazette notification dated 24th of May 2010. He has referred to section 14 of the Amendment Act of 2010 as running page 54, and has submitted that in such circumstances the same cannot be made applicable for the period prior to the amendment. The learned counsel has further submitted that the petitioner has taken a plea that no person beyond 75 years had ever approached the petitioner for seeking any medical benefit, and therefore the reason for rejection is itself perverse. The learned counsel has further submitted that otherwise also, as per BSI, some contribution is required to be made for availing facility post-retirement, and the petitioner is providing free medical benefits post-retirement up to the age of 70 years. With respect to the third reason for rejection, the learned counsel submits that the petitioner is a valid concern and there can be no occasion for grant of any unemployment allowance, and therefore there was no requirement to make any such provision. And the learned counsel submits that the third reason is also perverse. So far as the fourth reason is concerned, the learned counsel submits that it has been mentioned that no retrospective exemption can be granted. He submits that such reason is especially perverse in view of the fact that the amendment refusing to grant retrospective exemption was introduced only in the month of June 2010, and prior to that there was no such provision. And further, once the matter was remanded to the authority for fresh consideration by virtue of an order passed by this court, such technical reason would not have been a ground for denying exemption. The learned counsel has referred to the following guidance. The learned counsel has also submitted that in the rejoinder they have annexed the exemption granted to the petitioner for the period 1/1/2015 to 31/12/2015, while notification dated 6/1/2016, and then for the period 1/1/2016 to 31/12/2017, while notification dated 9/6/2017. The learned counsel submits that when exemption has been granted for the period 2017, 2015, and 2016, there can be no reason to deny exemption for the period 2005 to 2010. The learned counsel has relied upon the following judgments: A. 2022 SCC Online Calcutta 3998 Para 16 and 25. To submit that for different years, the petitioner cannot be treated differently. He has then relied upon the judgment reported in 2000 SCC Online Gujarat 605 Para 10 on the same point. The learned counsel has further referred to the judgment passed by Honorable Supreme Court reported in bracket 2006, article 6, SCC 581, and has submitted that during these years, on account of absence of exemption, the petitioner has been provided all medical facilities to the concerned employees / retired employees, and they have already incurred huge expenses on that count. And if any amount is directed to be if the petitioner is made to pay any amount to the respondent ASIC for the same period, the same would constitute undue hardship to the petitioner. He has submitted that in the aforesaid judgment there was an interim order passed by the High Court for to continue to grant medical facilities to the employees, and no such interim order is available with respect to the present case for the period. But the fact remains that the petitioner has been granting the medical facilities during these years, as the employees / retired employees used to come to the petitioner and the facilities provided by the petitioner, and it is not the case of the respondent ESIC that they provided medical facility to even one employee. The petitioner cannot be put to double expenses on account of the medical facility, one by providing facility themselves and other by providing contribution to ESIC. The learned counsel has also relied upon a judgment passed by this court dated 24/7/2025, passed in WPL number 4766 of 2022, which paragraph I will reference.
56 only, page 168. This court finds that some of the provisions of ESIC are better and they cover wider range also, but if the same ground is allowed to stand, then the hospitals opened and managed by the petitioner company and its associates will become redundant, and their machines will also remain unutilized in business. It is further evident that hospitals of the petitioner company are running from much earlier before the establishment of the hospital of ESIC. Thereafter, Lakshmi kindly come to paragraph 61. However, so far as the ESIC hospital is concerned, workmen are not aware of the work culture of the hospital. They are also unknown to the environment, and even the distance may be relevant factor in getting the regular treatment of PD as well as hospitalization. Management may not be aware of the number of doctors, staff, and working strength of the ESIC hospital. Therefore, this could find that there may be disharmony in the inconvenience of the hospital. This court is also of the view that existing hospitals of the petitioner may not be allowed to discontinue as it will cause undue hardship to its workmen, also to the workmen. This court further is of the view that choice should be given to the employer and the workman independently to adopt the procedure of treatment of the workmen in the hospitals of ESIC or its associate hospitals. But they cannot be forced and compelled to look into the treatment of ESIC hospital, and the management may be asked to upgrade the facilities of the hospital as part of the ESIC hospitals from time to time, and also to revise the beneficial schemes in the light of the government policies. But it has also to be dependent upon the volume of the workmen and requirement of the work. This court is of the further view that the management of the petition company may be accountable for the maltreatment of the workmen in the hospital and for poor treatment of the workmen in its hospital, but ESIC hospitals cannot be held accountable. Therefore, choice should be given to the workmen by making them aware about the benefits and facilities granted by the management hospitals and ESIC, but management may not be forced to close its hospital and medical units abruptly. The distance of the hospitals in some cases may be very crucial, and it relates to life and death of the workmen. Workmen working in the mines or in the steel factory doing hazardous job in the industry may require medical attention immediately in the case of suffering from sudden injury or in untoward incident reserved in the factory. Even the management and its officers are well aware of the seriousness of the injuries and grievous injuries of such workers. Hence, the persons working in such factories may require instant and instantaneous medical attention instead of attention from the management side, and instead of arranging vehicle and doctors at a far away place. The ESIC hospital is in Adityapur, which are unknown to the workmen and their union and their family members. It is evident that all the above breed petition, the companies are not charging any contribution from its employees regarding medical treatment, and the petition company are providing free of cost to its employees the entire medical expenses, which are borne by the management of the petition company, whereas treatment in ESIC is possible only after taking contribution from the petition company. Thus,
The learned council has also relied upon the judgment passed by a 40th bench of this court in WK number 4766 of 2022, decided on 24/7/2025, and has referred to paragraph 256, 61 to 75 of the said judgment. To submit that the said judgment squarely covers the case of squarely covers the present case. To submit that this judgment has attained validity. However, during the course of arguments, it transpired that altogether how many repetitions were there? 4 repetitions were disposed of, and the period seeking exemption has been given in a chart which related to the period 1/4/2021 to 31/3/2023. That's all.
regarding the first.
The learned counsel, the learned counsel for the ESIC has proposed a prayer and has submitted that so far as the and has submitted that in the earlier interview order 4 reasons were assigned, but neither anything was placed before the authority to satisfy the 4 reasons, nor any material is there before this court to satisfy that the 4 reasons do not exist. With respect to the first reason, the learned counsel has submitted that the medical facility with regard to dental care has not been mentioned in the writ petition. However, in the rejoinder, they have annexed a copy of memorandum of the year 2023, and no further material has been placed on record to show that the facility was available for the period involved in the present case. It stands admitted that during this period, no such facility was available. With respect to second contention, the learned counsel submits that the ESIC Act, as it stood for the period involved in this case, also provided for benefit of persons who attain the age of retirement / voluntary retirement / premature retirement and their spouse till their death. And there is no age limit prescribed, but what the same was subject to payment of some contribution. But the petitioner admittedly do not provide any medical facility post the age of 75 years. With respect to the third ground, the learned counsel submits that nobody can anticipate as to when a company would go for liquidation, and therefore the provision of unemployment allowance is required to be made so that such contingencies can be taken care of. He submits that the stand of the petitioner that they are running concern and there is no question of any payment of unemployment allowance is completely misplaced. With respect to the fourth reason, the learned counsel has submitted that the learned counsel has nothing to say.
2010 का भी period इसमें involved है, तो 2010 का
The
part
learned
period.
counsel submits that part period of the year 2010 is also involved. However, it is not in dispute that
इसीलिए लिखा
the
है
matter was remanded to the authority for consideration by virtue of order of this court. The learned counsel has further submitted that the ESIC Act is a beneficial legislation and there is no concept of control. Guys, go draft judgments.
same judgments or सिर्फ एक
कोई
और
याद नहीं है.
I'll just place it on. Just two more things. There are two applications which were submitted by the petitioner. One is at page number 40. This is for the year 2010 writ petition. And the second is at page number 46.
The learned counsel submits that the petitioner had submitted two applications,
Both in the year 2010.
both in the year 2010,
This is why you have example, you have cited same
Just-
performance.
to cover the entire period.
2006.
And in the application, it has been mentioned that total number of employees for wages for coverage would be 415. In both the
नहीं,
applications,
दूसरे में है पेज 46 से चालू होता है. This is for the year for the period 2006 to 2009, जिसमें 389 है. And they also submitted an application for exemption after the period had expired so far as 2009 is concerned. Page 46.
At page number, this is for which period, from where do I get?
Page 46 is from 2006 to 2009, and page 41 is for 2010.
Okay.
Page 40.
At page 41, the
I'm sorry,
period
page
is 2010,
Only 2010.
only 2010. And the number of employees having less than rupees 10,000 per month, excluding overtime allowance, etc., has been shown as 415. And the second application is at page number 47, which
46
is for
ones. 46 ones.
46 for the period
2006 to
2006 to 2009, and it is dated 23rd February 2010. And the application indicates that there were 389 employees who were getting remuneration of rupees 10,000 per month or less, excluding overtime and allowances. The learned counsel submits that the application seeking exemption was primarily filed beyond after the expiry of That's all.
And judgments, I'll just repeat those.
However, this aspect of the matter is not the reason for rejection of the exemption.
Lordship may just have my compilation.
After
हाँ
compilation.
एक था लॉर्डशिप बोले थे कि जब भी ये केस रहेगा लॉर्डशिप सीरियल नंबर 5
नहीं है citation बताइए कोई ऐसे ना
लॉर्डशिप 2019 SCC ऑनलाइन
2019
SCC
online
दिल्ली 8751
Delhi 8751 para
para 9 10 11 this is with regard to general principles of judicial review 9 10 and 11
The learned council has relied on the judgment passed by Honorable Delhi High Court reported in 2019 SSC online Delhi 8751 para 9 10 and 11 to submit that the scope of judicial review in such matters is limited.
Marvelous.
Okay.
The second would be I'll not repeat it Marvelous. The second would be hardship is immaterial. One of you.
Yes.
This is 2013 SCC online Karnataka 2500
Karnataka 2500.
page number 2500 sorry para 18
The learned council has relied upon the judgment reported in 2013 SSC online Karnataka 2500 para
18
18 to submit that the ESIC Act being a beneficial legislation, the hardship of the petitioner is immaterial.
with regard to prior exemptions those is not a case of one I'll just come to that with regard to prior exemption this is not a right 2016 SCC online Kerala 39471
39471.
471 para 3 to 6 prior exemption is not a right
The learned council has then relied upon the judgment reported in 2016 SCC online Kerala 39471 para 3 to 6 to submit that merely because there has been a prior exemption, the same does not confer a right for continuation of exemption for subsequent years. He has submitted that in the present case, the exemption which has been brought on record
Yes,
relates to subsequent periods, that is 2015 and 2016.
and just two distinct factors with regard to judgments 2024 SCC online Gujarat 605 this is also a case where there was a prior exemption
So far as the judgments which has been relied upon by the petitioner passed by Honorable Kolkata High Court and Gujarat High Court, in both the cases there was prior exemption.
Exemption.
उसमें भी कलकत्ता में
और कलकत्ता need to check
कलकत्ता में है
गुजरात में है prior exemption
कलकत्ता की केस है कलकत्ता वाले जजमेंट में
गुजरात में है para 22 और 23 para 22 में
is referred to
sorry
para
page
22 and
नहीं
23
I'm sorry page number 22 compilation का page 22 में
कलकत्ता में 2020 to 21 का में एग्जेम्पशन मिला हुआ था और एग्जेम्पशन रिफ्यूज था 19 to 20 प्रायर पीरियड का लॉर्डशिप में काइंडली से पैरा 25 ऑफ दैट जजमेंट पेज रनिंग पेज 20
page you see para 9
being agreed by the order dated
para 9 is something else page 25
that is the other judgment Calcutta judgment लॉर्डशिप में काइंडली से पैरा 25 पेज 20 The respondents cannot thus be permitted to use two different yardsticks for the same unit for two different periods, notwithstanding the medical benefits for the workers remaining the same. The respondent number 1 has been granted exemption for the under section 87 of the Act to the petitioner for the period 1st April 2020 to 31st March 2021. Would not deny the benefit of the petitioner number 1 for the period 1st April 2019 to March 2020.
For Gujarat there was a previous
and Calcutta
in
it
the
was
judgment passed by Honorable Gujarat High Court there was exemption for the previous period. But so far as the judgment passed by Honorable Kolkata High Court is concerned, in paragraph 25, there was an exemption for subsequent period, but it was also observed that for the same medical benefit to the workers, different yardstick cannot be obtained from for different use.
And the Gemco judgment, paragraph 57, my lords, the petitioner had a hospital in those cases. It was a categorical statement that they have a running hospital. Paragraph 57.
With respect to the judgment passed in WPL number 4766 of 2022, the Learned Council has referred to paragraph 57 of the judgment and has submitted that the petitioner company was exempted for the period.
I'm sorry, paragraph 56, my lords, paragraph 56.
Paragraph 56. He has already referred.
So I'm just
To submit that the petitioner in the same case was having an independent hospital.
they have opened and managed their own hospitals.
And they opened and managed their own hospital, and the period of exemption granted earlier was also recorded in para number 57.
My lords,
That is for 14-15, 15-16 and 16-17.
definitely.
That's all.
My lords.
Next, इसका similar वाला कौन सा?
279.
27. The reasons are the same.
Reasons are the same. What should we kindly come to annexure 5, the rejection order? It has been passed just after
Annexure 5. The previous order, let us see the previous order.
here. There is no previous order.
Where is the
The
exemption?
annexure 5 will not by way of supplementary report. It was in implementing letter.
This is for the period.
So for the period January 2012 to December 2012.
What is the ground for challenges?
Yes. Now should we kindly come to para 10 of my pleadings? That it is stated, yes. That it is stated the petition company had already submitted documents to show that they had entered into an agreement with Tata Main Hospital, Teamplate Hospital, and Tata Main Hospital, Jamshedpur, with respect to dental care of its employees. This apart, petitioner company has empaneled eminent dentists on the promise of providing dental facilities to its employees. Now, Rashid, we have also brought in about the agreements with all the three hospitals which we have.
This is January 2014 to December 2012. ठीक है.
That's what tapping in.
कौन सा period का है?
January 2012 to December 2012.
This is for the period 2012.
12. क्योंकि 14 से 12 नहीं हो सकता है.
वही तो absurd. So, what do you want to say to this?
Lordship kindly say they have filed a counter affidavit.
No, which all documents have been brought from
So all the agreements with the hospitals. First agreement is Lordship page 34 with Tata Motors Limited.
This is of 2009. 20th November 2009. Then, where have you mentioned about your dental services?
It provides for all medical facilities. It is a super specialty hospital.
So these, just a moment, these, there is nothing specific mentioned about them
Yes. Neither dental services have been excluded nor your lordships
included.
yes. And we have made a statement that we have empaneled also dentist. Your lordship, next is your lordship will find. Next agreement your lordship will find.
2011. Page 47.
Tata Steel Limited and Tata Cummins. This is with respect to TMH.
Okay, these the documents were filed before that.
Yes, we have stated that we have filed and they have not
And they are
denied.
not considered.
Yes, and they have not denied it also that it will. But next is Teamplate Hospital, page 60.
Just a moment. Annexure 4. where have you stated that it was filed and when was it filed?
When was it filed? It was not mentioned, but we have stated para 10 if lordship says. Petitioner company has already submitted the document to show that it has entered an agreement with Tata Main Hospital, Tinplate Hospital, Tata. Actually, it should be yes, the Tata Main Hospital and Tata Motors Hospital. It should be with respect to dental care of the employees. This apart, petitioner company has also empaneled eminent dentists of the town for providing treatment facilities to its employees.
So this would be responded to by the council for the state, no?
State has also filed counter and
Let us see.
both of them.
Let us see what is the response to para 10.
Counter affidavit of the state paragraph. Paragraph 17
Was not submitted. Page
but they
14.
do not deny regarding
At page number 14, they say it was not submitted. Page 14 on the count of the state.
it is an affidavit dated 10/9/14 shown by Dr. Dhirendra Kumar.
This is by Dr. Kumar Singh.
Yes.
Insurance medical officer.
Basically, we cover the corporation, they cover the medical facilities other than the corporation. So this is by the state.
This is by the state.
This is by the state.
What is the response to this paragraph?
Lordship,
These
page number 14,
agreements have not been
not been
filed.
submitted,
They
not
say.
submitted.
But they do not deny your lordship the other part of the statement that we have impaneled eminent witness.
How do you say, you see, these materials you have not brought on record? What else?
Lordship, they say that lordship, the statement made in paragraph 10 is in two parts.
Yes. And where is the empanelment? Where is the empanelment? You have said that you have empaneled.
Yes.
Where is that empanelment? That is not supported by any document. You have empaneled who? And when?
That is not on record. But there is a statement, your lordship, and that is
Statement,
not
what
denied.
statement? No, you have to substantiate your own statement. Well, once you make that you have prepared a panel for empanelment of doctors, where is that?
That is not on record.
And in which hospital have you empaneled them? In
Dentist-
your own hospital.
No, empanelment is of the eminent dentist. This besides the
Right?
hospitals.
So empanelment must be having a list.
Yes, we have
There
a
has
list.
to be a
Lordship, that is not filed in the
that
data
is not
application.
fine. You see, we do
But
not-
they have not denied it.
how will they are going to Mr. Siddhas, please do not tell
Lordship,
me.
they
If
may
you
say
make a
that the statement is beyond record.
if you make a statement
Yes, lordship.
in the writ petition that you have empaneled,
Yes.
is it not your duty to bring that empanelment letter on record? Or we will check it by the counter?
Lordship, once they
It is
do
not
not
there.
dispute it,
No, we do not take this.
once they do not dispute
That's
it,
right.
lordship, that is.
You take it.
In this case also, lordship, annexure 9 page. We have not record the earlier exemption. That is by way of a supplementary affidavit dated 16/1/19.
Earlier exemption
Earlier exemptions.
for the period.
Same period, your lordship.
This is for the period 2012.
Yes.
Understood.
Those
2015 and
16,
2016.
not the earlier. Those are not earlier.
No, not earlier period. 2015 and 16. पिछला वाला रेट में भी हम बोले सब्सिडेंट पीरियड का लगाया है.
So
Yes, facts otherwise are same. And one more thing we have stated in also in business that so far as para 3 we have stated that this is a company here also, because one of the issue which has been raised here also by my learned friend, that this company do not have their hospital on their own. Tata Motors have their hospital. Also we can see para 3, this is a company incorporated and is a joint venture of Tata Motors Limited and Cummins INC USA.
It is a different company.
It is a different company, joint venture, and one of the partners of the company has there, and it is located also within the Tata Motors premises, because each manufactures the engine for the vehicles which Tata Motors produces. That's it. And we have also checked the constituent member that the Tata Motors, it has also been granted exemptions here, checked that we have noted by way of rejoinder.
Audit period Tata Motors has been extended.
Is it not so?
Which period Tata Motors has been
Also,
extended?
the exemptions which you have brought on record is 1/4/16 to 31/12/17
Of Tata Motors.
Tata Motors. 1/4/15 to 31/3/16. Thereafter,
Nothing for this period.
1/4/11 to 31/3/2012. And not for exactly this period, but all other periods were brought on record. Yes, part of the period. And 1/1/2004 to 34/2008.
Where is that?
Also that we have brought on record in our rejoinder annexure 8 series. Also rejoinder to the counter affidavit, which was dated 20th August 2018. Just after the constitution.
Date August 2000.
18. It's shown by one Nikit Kumar here also.
Tata Group of companies had problem. Big place of gold is both major problem. Supplementary, counter, rejoinder, supplementary rejoinder. The things which are already within your knowledge, you don't disclose it in the petition. You come out for the first time in rejoinders, in supplementary affidavits. यहाँ तो कोई सिस्टम नहीं है ना कि विदाउट द लीव ऑफ द कोर्ट यू कैन नॉट फाइल सप्लीमेंट्री सुप्रीम कोर्ट में फाइल करके दिखाइए बहुत मुश्किल काम है सप्लीमेंट्री एफिडेविट सुप्रीम कोर्ट में फाइल
Will be any affidavit without the legal.
ऐसे नया काम करेंगे तो काउंटर रिजॉइंडर इट्स नेवर एंडिंग गो ऑन एंड ऑन सिविल कोर्ट में भी अमेंडमेंट पिटीशन है यहाँ कोई सिस्टम नहीं यहाँ जब जिसको मन होगा तब फाइल करेंगे मिक्स ऑफ द आर्गुमेंट में भी फाइल करेंगे पार्टनर मैटर व्हाट डू यू वांट टू से
Actually, rejoinder may if also also.
हम लोग सप्लीमेंट्री आ
The supplementary may if
16/19
supplementary.
हम will rejoin
Yes.
2880
Yes. Worship kindly come to page 19, section 8. All their exemption orders are there.
period to say
Which is first order period 2001/4/16 to 31/3/17. Second head worships 1/4/15 to 31/3/16.
1 for 15 to 16
Next head worships 1/4/11 to 31/3/12.
1 for 11 to 31/3/12
Next head worships 1/11/2004 to 38/4/2008.
The learned counsel for the petitioner is making this petition has been filed for the following reading. The learned counsel for the petitioner, while referring to the interim order rejecting the claim for exemption for the period 2012, has submitted that, has referred to paragraph 10 and has submitted that the petitioner company submitted documents to show that they have entered into an agreement with Tata Main Hospital, Pinfield Hospital, and Tata, दो बार Tata Main Hospital. कौन सा बार है उसको? क्या बोल सकते हैं? टेल्को हॉस्पिटल.
एक टाटा मोटर हॉस्पिटल है.
एक टाटा मोटर हॉस्पिटल.
गलती से 2 बार
with respect to the dental care of its employees. Apart from that, the petitioner has also empaneled eminent dentists of the town for providing dental treatment facilities to its employees. The learned counsel has then referred to the enclosures, to the annexures. However, no such list of empaneled eminent dentists of the town for providing dental treatment facilities to the employees has been annexed with the petition. The learned counsel has submitted that the agreement between Tata Motors Limited, which is dated 28 November 2009, has been placed on record. Apart from that, an agreement with Tata Steel Limited has also been, which is dated 7 May 2011, has been placed on record. Where is the third one?
First one is at page 3. Second one, your lordships, is at page 47.
Yes, where is the third one?
Third one is at page. Third one is at page 60.
Another agreement termed as medical facility to Tata Consults Limited employees and their dependent family members at Tinplate Company of India Limited Hospital, which is dated 2nd of September 2010, has been placed in page 60, and one more document at page 63. The same.
Okay, this is Dr. T.C. John Memorial Charitable Foundation.
At page 63, titled Medicine Facility to Tata Consults Limited employees and their dependent family members at Dr. T.C. John Memorial Charitable Foundation Medical Store. And has submitted that these documents have not been considered by the authority by passing the interim order. The learned counsel, during the course of argument, the counter affidavit filed on behalf of the state, which is dated 10/9/2014, has been placed, wherein the paragraph 10 of the petition, with respect to paragraph 10 of the petition, it has been stated that the agreement which has been annexed by way of annexure 5 to the petition was not submitted by the petitioner company during the course of hearing on the application seeking exemption. The learned counsel submits that it goes to show that it is an admitted fact that the petitioner has also empaneled eminent dentist of the town for providing dental treatment facilities to its employees, irrespective of the fact that neither any date of empanelment has been mentioned, nor any such list has been annexed along with the petition. The learned counsel has then referred to the judgment, the exemption granted to the petitioner to Messrs Tata Motors Limited for the period from 1/4/2016 to 31/3/2017, 1/4/2015 to 31/3/2016, and 1/4/2011 to 31/3/2012, which has been annexed along with the rejoinder filed on 28/2018. The Level Council has further submitted that so far as the petitioner is concerned, exemption has been granted for the period 2016 and 2017, which has been placed on record by way of
Also in the rejoinder affidavit itself as annexure 8 series.
Act in the rejoinder application itself as Annexure 8 series.
Those are Tata Motors.
Those are all Tata Motors. They got Tata Motors Vancouver exemption for the period 1/11/2004 to 30/4/2008.
Supplementary measure.
Tata Cummins,
Supplementary, my lordship. Supplementary measure.
Hmm.
Supplementary affidavit, page number 5 and 6.
by way of supplementary affidavit dated
16/1/2019.
dated 16/1/2019, which relates to the period 2016 and 2017. With respect to
The petition.
other grounds, they are the same.
Yes.
Just discussing.
Also, one more thing. If they say that the agreements were not produced, then they could have rejected it, saying that we don't produce any medical, we don't give any medical facilities, because in absence of an agreement, so giving medical benefit till the age of 75 years is without any basis. But they acknowledge that we give it to the hospitals. So they are saying merely by denying that agreements were not produced. So they, once they admit that till 75 years of age in the same appeal order, they admit that we provide medical facilities to our ex-employees till the age of 75.
These documents do not refer to any 75 years of
No,
age.
these are agreement for our.
See, those things would come in your terms and conditions of employment, not in the agreement.
Yes, but if you don't have an hospital and don't have a tie-up with any hospital, and barely we are mentioning in the wage agreement, is not sufficient. They said that this wage agreement is without any basis. There is no place to provide any medical facilities.
Just two submissions. They applied page number 24 in June 2013 after the period.
The council for the respondent has submitted that the petitioner had applied for exemption in the month of June
2013.
June
They have annexed.
2013.
But this is for the year 2013. Those are
Those are
Bharat.
valid. After the expiry of the period of exemption.
Inadvertently, the agreement for exemption application for the year 2013 has been annexed. Not 2013.
And it's
That application is not annexed, and they have not taken it as a ground for
That's
exemption.
right.
the second.
Just a moment. The learning council service said the petition had applied for exemption after expiry of the period. And however, it is not in dispute that the same is not a reason for rejecting the claim for exemption. That's all.
The second would be in all these agreements, there was an upper limit of 3 years, which fell within the 2012 period itself. There is no further agreement reviving this agreement. Those are Bharat agreement. This is December 2012. बहुत सा agreement April 2012 में खत्म हो रहा है, अगस्त 2012 में खत्म हो रहा है. कोई revival नहीं. I just bring that process. Page number 34. This is with Tata Motors Limited. Page 37, this is expiring in August 30th, 2012. 3 years.
The Learned Counsel has referred to an issue filed and submits that although this agreement was not filed, but on the face of the agreement, it expired in the month of August
30 2012.
30, 2012,
बाकी का भी वैसे ही है, सब during midway of 2012.
which is the agreement dated 20th November 2009. The agreement dated 7th May 2011 expired.
This is also for 3 years.
And it was valid for 3 years, but certainly it covered the period involved, right?
And the third is during this period, page 65, it was valid till 30th April 2012.
The agreement at page 65 was valid only till
30th April 2012.
2012.
And
And the agreement, there's one more,
page 62, valid till 31st March 2012.
and the document at page 62 was valid till 31st of March 2012.
And the third count is they said that Tata, they are basically Tata under Tata Motors Limited. If they were under Tata Motors Limited, there was no requirement of a separate agreement. They're a separate company, got binded to a same different
The
terms.
Learned Counsel for the respondent has also submitted that even if the petitioner,
Para 3.
the Learned Counsel has referred to paragraph 3 of the contract with it to submit that each company separately is required to comply with the provisions of law, and merely because they are the subsidiary or the
Joint
or part of the group companies of Tata Motors Limited, the same does not give them a special status.
And they had entered into a separate, this certification is from page 34, that they had to enter into a separate agreement for medical service with Tata Motors.
Page 34.
Matters.
He says that there is a requirement of an agreement and therefore.
The Learned Counsel submits that in order to claim any benefit from Tata Motors Limited or Tata Steel Limited, a separate agreement is required, which itself shows that they are not automatically entitled to the benefits which are available for the employees of Tata Motors Limited and store for Tata Steel. This is over.
And same.
What about other two?
There are two different grounds.
Was it an order after demand?
No.
What are the periods involved?
2017, in 3 days, this 2017.
और बाकी सारे सेम जजमेंट्स हैं
जी.
आपने जो अपने जजमेंट्स को ये कॉपी प्रोवाइड
I'll again do it. That's a soft copy भी आ गई.
सॉफ्ट कॉपी दिए हैं
जी हाँ WhatsApp में कर दिए थे. फिर कर देना.
So it is 2017 and other is 2018, 19 and 20.
2015-16 का मिला हुआ है, 2017-18, 19 का रिजेक्ट किया है. इसके बारे में आपको क्या बोलना है?
तो इसमें 4 डिफरेंट ग्राउंड है. इसको सैटरडे को रख दे रहे हैं. लॉर्डशिप इज ऑलरेडी फिक्स सम केसेस ऑन सैटरडे.
The remaining cases on Saturday. Saturday को कुछ बेल रखे आप सारा दिन को नहीं पाया सब्सिडी वाला बेल.
जी.
So it took some time. Around 18 mails from today it has gone. 3 are already posted.
Saturday 2:15. Saturday 2:15 itself.
Saturday को
सैटरडे लॉर्डशिप लिस्ट में रहने दिया जाएगा.
लिस्ट में रहेगा. Saturday को फर्स्ट हाफ सेकंड हाफ का नहीं बना.
Definitely.
बेल खत्म हो जाएगा तो लॉर्डशिप.
हम लोग एक आध केस और रखे हैं लेटेस्ट वो भी रखा हुआ है.
सहारा
सारा में तो हमको आईए पर ऑर्डर करना.
जी.
जब तक आईए पे ऑर्डर नहीं होगा तब तक कुछ होगा. 3 आईएस आपको and then only the court can see. First ये सी नहीं 2 केस है ना. एक ये है 2354. I will not know it.
just give the serial number.
एक है 23
1 and 2. Serial number 1 and 2.
एक है 388.
27.
नहीं.
Okay.
2354 2794.
So serial number 1 and
2794. 1 and
2.
हाँ, ये वाले जो जजमेंट्स है ना ये सारे केसेस पे लगते हैं. इसको अलग से रखिए. और हाँ ये वाला भी साथ में रखिए और जब वो डिक्टेशन होगा वो तो होगा ही। ठीक ये वाला किताब के साथ